Hello. Well, I did get back from Virginia. I did that other broadcast from my laptop. I think it worked out pretty well. Sorry, I've been a little bit slow getting back. I'm one of those people when I travel, I seem to pick up things, or at least messed up my diabetes. Made me a little woozy. Last time I'm taking a train, I'll tell you that. That's about 4 days of my life. I won't get back. What I would like to talk to you about is legal, or the law, involving English as a second language learners. To put this succinctly, except for pointing out requirements in the law to your administrators, or to those who want to do things the right way, or coworkers or peers, etc. You're not going to settle the problems in your school by filing a lawsuit, going to file a civil rights complaint, etc., etc. Those can work, but they work very slowly, and they may or may not work, period. As we look at these laws, I'm going to talk about a few of them. You're going to notice one trend. Early in the 20th century, it was very popular to suppress minorities and their languages for different reasons. Now, I've talked to you about the English, I've talked to you about the three different levels of cultural interaction. The first being invisibility, which means if a group in the community is invisible or just not taken into account at all, or just taken for granted to where people don't even notice them, then they're not going to do anything in particular to promote that culture or to work with the ESL kids. I've seen that in schools, ESL. Saw that in Oklahoma, where they basically put the kids in the back room and waited for their parents to leave town so they could trot them out and let them go. They didn't provide any kind of education for the kids at all. Okay, that's why that invisibility stage I pointed out is so deadly, is because when you're invisible, you're nothing. You don't even count. People don't even see you. They don't hear you. You might as well be a ghost. Okay, now the second stage was really relevant to the early 20th century and really even the late 1800s. For those of you who have studied American history in some detail, you may have heard of some things called the Exclusion Acts. This applied, I know to Chinese, and also I think to Japanese in California in the late 1800s, early 1900s. These were attempts to basically force people to deport people. Only it wasn't self-deportation, as Mr. Romney came up with that term last election. It was forced deportation, and it was exclusively focused on Asians. You may not know this, but a lot of Japanese immigrated to California and the West Coast in the late 1800s to work. This same phenomena occurred in Peru. If you're not familiar with that, Peru has a large Japanese minority population. You get a lot of people named One Fujimori, or things like that, combination Japanese, Spanish names. So the defensive mode, that second stage I talked to you about, I talked to you about when I was in Virginia, that is very prominent in the laws shaped to deal with foreigners or with foreign languages, non-English languages. One of those early cases, and I don't know, maybe I dropped it already, but there was an early case where people basically tried to suppress the language of minorities so that they wouldn't even be taught even after school. They tried to just prohibit the language. Now, why did this come about? And this is important because you can link it to what's going on today in several towns in Nebraska and across the country where there are attempts to keep people who are theoretically or maybe undocumented. The term illegal is used. I call it undocumented. I don't feel calling a person illegal is, maybe a practice is illegal, but a person, they may not have their papers, but it's pretty demeaning to say, well, you just don't count at all. You shouldn't even be here. We can go back and forth on that if you disagree, but either case, undocumented is a lot safer term to use. Now, what do I want to do with this? Well, there were several cases in the early 1900s. One in 1927. I'm going to jump ahead a little bit. So I'm sending you this sheet. Where you see the green shading, that's what I want you to really read. I don't expect you to read this whole handout, but I'm not going to cut it down and just summarize it all. And then when you get in the back of it, you'll see yellow shading, which is an indication of that's talking about the people that are opposed to ESL or bilingual ed or heritage. That's kind of the pro-English, English is official language, and we're not going to accommodate people at all, or we're going to accommodate them some, but not too much, versus those that want to do everything possible for English language learners. Okay, so you got that. Green is pro-ESL or pro-bilingual. Yellow is going to be anti-bilingual and pro-English. Everybody wants to be pro-something, I'm pro-anti such and such, it's kind of comedic. In Farrington versus Togushige, I guess that's right, in 1927, there were laws handed down in Hawaii that they tried to put restrictions. You could not teach children Japanese or Chinese. And if I remember right, this was after school programs. So they were trying to make sure that you couldn't teach kids any Japanese or any Chinese, even on their own time. And certainly the district couldn't do it. So those were thrown out of court. So the court was pretty, I wouldn't call liberal, but it was understanding that you can't just tell people they can't use a language after school if they want to have an after school program. Now we got an actually interesting thing happening right now in the state of Arizona. They have what's called a Hispanic or Latino curriculum, and the state has banned that, and there's a huge fight over that. That is certain amount, the history deals with the history of Latinos, Hispanics in Arizona in the United States, and the state of Arizona is trying to eliminate that your district can't even have that program. Very similar to this, the district's also fulfilling the law, but now they're not only saying do what the state wants you to do, but the state will see something, they'll prohibit that even if you're doing everything else the state wants. As I mentioned, as I talk now, I see the law as very confusing. I see the law as depends on the court. You get a conservative court, you get a different ruling. You get a more liberal court, your side wins and your side loses, and the reverse for the other group. It mentions in here, it talks about, it goes all the way back to Plessy versus Ferguson, and then Brown versus Board of Education. In 1896, Supreme Court said that you could have separate educational facilities for African Americans, and that is okay. So you could segregate as long as it was equal. Of course, it wasn't equal. They didn't have the library, the books, the funding, etc. But in 1896, nobody cared. That's why when you look at these, the political implications are that unless the group is very active politically and has some real pull, they're not going to get a ruling that's going to drive them, it's going to really promote them too much. That's why not much happened. We didn't get desegregation in 1896. It wouldn't have happened. By the way, Brown versus Board of Education, 1954, 9-0 ruling said that Plessy versus Ferguson was unconstitutional. You could not segregate people by their race from schools. Now that started in 54, and integration took about 13 or 14 years. That was not automatically instituted. It took several hardcore conflicts between governors and mayors and the federal government to desegregate schools. Now they're back to being segregated again, but it's not by law. It's by other means. That's another issue could come up in law. Okay, now, so we know that in that case I just mentioned about Chinese and Japanese, you couldn't prohibit it. Nebraska, and you have to remember something, it wasn't just the fact there were a lot of Asians here. Also in World War I, Germany was the enemy of the United States. Ironically, Japan was an ally. People forget that. So was Italy. Meyer versus Nebraska, the state of Nebraska tried to prevent schools from offering German as a language to children unless they were at least 8th grade. Laying on the line, German was seen as the language of the enemy. A lot of people made statements that German was an anti-democratic language by its very nature and autocratic and brutal. Germany got a very bad reputation in the First World War, and I always thought that wasn't deserved, but after I read some books in World War I, Germany, their foreign policy and their treatment of Belgians and neutrality and their brutality towards civilians was absolutely hideous. And so people thought they'd get back at them by going after Germans in Nebraska, but more specifically after German speakers in Nebraska. You know from the history in that other book, talking about the history of language rights in the United States, and well, that's also in Wiley, that German was tolerated as a major language in Ohio up until the 1850s. It really wasn't until after the Civil War that the energy of the United States was focusing on being an American and agreeing to certain principles. Maybe that was part of the Civil War. In healing the Civil War, we're going to force everybody to band-aid themselves together and see the United States as one country. That certainly didn't help that attitude, or at least drove that attitude. In Myers versus Nebraska, they sought to close a loophole. I'm just going to read it from here. You could not teach a Bible story in German to a child if that child was like 10 years old. You could actually be fined for that. And that was parochial schools, by the way, good old Lutheran Catholic schools. The Supreme Court said the government can decide what language will be used in the schools, but it cannot attempt to prevent people from offering languages in the schools on the side. And I said on the side. It didn't say the state says you have to teach Spanish and French, and you can't teach German. Now, they wanted people to study, but as you know, as you suffered, you studied Spanish or French or German in high school when it didn't really help you very much. You weren't, the idea of teaching it. And this is a very sensitive issue, and you have to go back to the defense mechanism of that second stage. People are afraid of a language they don't understand, and they see it as a threat. So you have to take all this into account. I'm going to try to keep this pretty short so I can get on to another one tonight. Now, those are all ethnic or heritage speakers. Okay, that's an issue that's come up with Spanish speakers. Now they want to offer Spanish courses in high school or middle school or even elementary with a dual language like we have in Lex to children whose family they're actually learning to academically use a language that they already know from home. Okay, that's kind of like the Germans back in the Meyer days in early Nebraska back in the 20s and 30s. Now let's switch over. ESL. The Lau versus Nichols is a Supreme Court decision in San Francisco. it was done in favor, it was decided in favor of Chinese students who they just put them in the classroom and said, figure it out. Okay. There was no attempt. Now, it was written by William O. Douglas, who was Supreme Court, not the, it's the Warren Court. It wasn't quite the court of the 60s. It gave Miranda rights and other things like that. But it's a court that said you have to treat students according to their needs, essentially what they're saying. You can't put Chinese students in a room and teach them in English if they don't understand and say, that's too bad. So that's one thing that was very important. Now, Lau is often quoted saying that, well, Lau says there are remedies. And then you go to the Title VII Bilingual Education Act and Office of Civil Rights, where there's a website. I'm going to include that for you, that you need to, and Lau's remedies are these: identify, evaluate the student's language skills in English, determine the appropriate instructional treatment, decide when these, they used to call them LAPs. We use English language learners. We don't use LAP, limited English proficiency. See, I have limited French proficiency, so I'd be LFP. So that's kind of cool. I'm trying to look at the camera. Sorry about that. Essentially, Lau established a series of tests. Oh, it also said determine the standards that need to be met by the teachers. I'd already mentioned about when are these kids ready to go back in mainstream classes. And so you were supposed to have a program, an ESL program. You're supposed to do something to meet their needs. You don't just say, hey, you should have learned English before you came over here, kid. What'd you do on the plane? That's some of the irrational beliefs of the people in defense mode. They say, why didn't you learn English when you were coming over? Didn't you know? I didn't know my country was going to be ripped in half by a civil war. That I was going to be orphaned, you know. So there have been some rulings that protected bilingual education. And there's one in here. Bilingual ed attracts flies like a dead cow. It just, and the flies are the enemies of bilingual ed, or they see it as anti-American, or they just see it as a waste of money. And so right after Lau was decided, there was a reaction. And at that time in the 70s in the United States, that was the time of the silent majority. Nixon, actually in 74, I think it was 74, I know it was 74, was going to be impeached and removed. So he kind of lost his voice there. He kind of disappeared. But Richard Nixon brought about the reorganization of the Republican Party, and they drew on a lot of support from Southern states, whereas previously Southerners were Democrats and hated the Republicans. But in the 70s and 80s was pretty much a Republican era, or conservative, you want to call it, because those could be put in the same button. Or in the same basic box, I think, or labeled the same way. And there was a reaction, and it was a defensive reaction. It's totally predictable. See, when you think that these when I talk about defense, like, well, that's really bad, they're mean and they're bullies, it's predictable. You get a new in-law in the family, and their family doesn't mix with your family, you get defensive on both sides. So I don't like to use those as good and bad. They're just observations of human behavior. I've seen many liberal person who did not want to accommodate those with disabilities. I've seen that with people that were very much, oh yes, I believe in helping others and all this stuff. And then the minute they had to comply and help someone with a disability or allow them to tape record their class, et cetera, they were opposed to it because the defensive mode is just a mode. A lot of resistance to bilingual ed, extreme resistance in California. And it's in here in this article. You can, if you want to read through all of it. I just hit the high points in green, and I'm looking at one now. in Otero versus Mesa County Valley District, and this was in Colorado. This court declared that there is no constitutional right to bilingual or bicultural education. Not constitutional. Okay. There's a lot of argument this week about what's constitutional from last week. But the courts immediately withdrew from the law. Here's what you have to understand. Courts do not want to run the schools. They want to preserve a modicum or a simple basic number of rights. But if the school officials feel that wearing a shirt like this would be disruptive, then the school official can say you can't wear that shirt in school. Just like they ban things that say have beer on them, or things that might be sexist or anti-this or anti-that. Anything that could cause conflict, So the school officials are given a wide latitude to maintain the peace. They don't have to, the courts aren't going to go into school and rule in favor of the third grade against the fourth grade. They're not going to have a lawsuit. Besides, the kids be in law school by the time we came through. Now, Castaneda versus Picard. This was a kind of a watering down of bilingual, but they did make a few statements in here. In Castaneda versus Picard, Jean-Luc, no, it wouldn't be. You came away with, and this is from Del Valle's quoted in this too, our author, that you have to do something for ESLs, but what you do for them is pretty much up to you. You just have to make the effort. And I would say pretty much neutered it. You have to provide education and accommodations for ESL, but it's not like special education. Now, I'm not that's not my area, but I know in special education, there are a lot of loopholes. I mean, there are a lot of hoops you have to jump through, hoops and loops, and you can't skip over them. You have to do an IEP. You have certain things you must do very mechanically. It's required by state law. ESL is way behind in that area. There's not really an IEP for ESL. Okay, so now the yellow ones talk about the group, and I actually took this from their website, the victories they claim against bilingualism. Because S.I. Hashikawa, professor at Berkeley University, I believe it's Berkeley in San Francisco, he was an American of, I think, Japanese descent, but he's American citizen. He wasn't, from another country. And he started the modern English only or English as the official language movement. His legacy, it was a pushback. It was the defensive mode. Are we going to become a multilingual country where we can't communicate with each other? That's not going to happen. But when people are concerned and they say, oh, you're going to make me publish all these rules, the state laws in Japanese and Spanish and German, no, you accommodate people, but, you don't change the government so it has to be trilingual. And a lot of people cited the example of the English-French controversy in Montreal and in Canada. And if you want to worry about that, you can look into the history of Canada. What they essentially did is they called themselves a dual language country so that Quebec would not separate, because there was a powerful French and a powerful English part of Canada, and they wanted to keep the country at peace. You'll see in some of these, this Silva versus Catholic Diocese of Wichita, 2008. And the one prior to it, this is, what is this one? I don't know, Nogales School District, that's what it is, in Arizona. Essentially, people arguing that you had to have bilingual education, that structured English immersion You can look that up, but basically it means that you go into a classroom where primarily or mostly it's taught in English, but it's structured in such a way to help it make it comprehensible and it's differentiated. And Justice Alito in this, he was already in at that time, he argued that that structured English immersion did meet the needs of these students. They didn't have to have bilingual ed. And the specter there, the fear that raises the defensive mode is that we create a dual language program in all the schools. And of course, that's not going to happen because we don't have the people to do it. And I mentioned some mere voter initiatives in other places. Now, in the text, when it talks in here about rights, it also talks about voting rights in the rest of the text. But essentially, you see this attack pretty broad, saying we want our ballots all in English, or we're worried of voter fraud and things like this. Those can be very bogus with no evidence. The issue of language is so central to what we are. We think in our language, so we can't really just dismiss it. I could be on the liberal side of this and say, oh, that's so racist or stuff. But essentially, it's a compromise. And that's why I advertise and ask you, barring a person who engages in an extremely, almost, I'd have to say, racist attack on a minority, you try to get all you can with as much candy and sugar as you can without resorting to any other sort of illegal warfare. Once you get into conflict, well, you can see it in American TV. Once you get into a conflict, it goes out of control. You do not own the conflict anymore. It becomes everything everyone else wants to impose on it. Okay? I could mention all these news services. They get on there and argue, and some of them are pretty bizarre, and the politicians running for office. I think if you want to keep it human and within your school, you try to persuade people. That's why I provide you these legal cases, so that you have something to stand on. You can see there are laws. Okay. Now, there is an Office of Civil Rights that you can approach. I think if you as a teacher try to initiate a lawsuit against your school, you'll probably not be there very long. Yeah, you might win a lawsuit against the school, but it's always good to get to help parents get a hold of someone who can then work with them directly. But I'm not arguing that you take no action, that you just look the other way. Yeah, I know, I'm not giving you an exact direction to go. I think you ask people who are in the know, who care about the minority community. You also have to see the needs of the whole school. So be sure that you see the big picture too. You are a community, and if you can, you want to try to maintain that the communal aspects as long as possible. Now, those are some of the laws. Generally speaking, right now, bilingual is kind of a dead issue to me. I don't think that's, I greatly applaud dual language programs. There's one, I know in Omaha, we have one in Lexington. But right now, I wouldn't advertise that as a solution, because it takes a huge amount of input, and you have to have a very, very large and fairly well-educated minority group who's going to be able to send people in to be teachers, and is going to show up at the school and support it, and are going to promote their heritage language. So it'll work if you're a big enough bilingual group. In other words, you may be a minority or even a majority as elects, but you got to stand up for your heritage, and you've got to also work with the others to see that being bilingual is a big plus for anybody. It doesn't matter what their ethnic background is. Okay, I'm going to stop this right now, put this up, and then I'll be sending you some more stuff. Thank you.